Ever wondered how a pharmaceutical company found itself at the center of one of the biggest health crises in American history, and what the Supreme Court has to say about it? Well, the story involves Purdue Pharma, the makers of OxyContin, a highly addictive painkiller. This company and its owners, the Sackler family, are embroiled in a complex legal battle that's traversed from bankruptcy courts all the way to the Supreme Court. The question at hand: can a company use bankruptcy protection to shield its owners from personal injury lawsuits? Let's dive into the chronology of events that led to the current situation. Purdue Pharma, a pharmaceutical giant, is infamously known for its role in the opioid crisis. This company, owned by the Sackler family, developed and marketed a highly addictive painkiller known as OxyContin. This drug, though initially touted as a revolutionary solution for chronic pain, soon became a catalyst for an unprecedented public health disaster. The marketing strategies employed by Purdue Pharma have been heavily scrutinized. They aggressively pushed OxyContin, assuring doctors and patients alike of its safety. This, despite emerging evidence of its highly addictive nature. In essence, Purdue Pharma was accused of prioritizing profit over public health, leading to an opioid epidemic that has claimed countless lives and wreaked havoc on communities across the United States. The Sackler family, the owners of Purdue Pharma, found themselves in the crosshairs of numerous lawsuits. They were accused of fueling the opioid epidemic through their business practices. These lawsuits were not just from individuals affected by the crisis, but also states and creditors who held the company accountable for the social and economic fallout of the epidemic. Despite the mounting legal battles and the growing public outcry, the Sacklers have expressed regret but continue to deny any wrongdoing. This denial has done little to quell the demand for accountability and justice from those who have seen their lives turned upside down by the opioid crisis. In 2019, facing multiple lawsuits and crippling financial implications, Purdue Pharma filed for bankruptcy. This move was seen by many as an attempt to shield the Sacklers from the financial repercussions of their actions. However, it marked the beginning of a complex legal battle that continues to this day, as we delve into the bankruptcy and settlements in the next scene. The bankruptcy filing by Purdue was a strategic move to resolve the lawsuits. It was a complex play, a gambit designed to solve the quagmire of legal proceedings the company found itself embroiled in. But let's rewind a bit to get the full picture. Initially, a settlement agreement was put forth, a mammoth figure of $4.3 billion. This was to be the price for Purdue's role in the opioid crisis, a financial recompense for the societal havoc wreaked. However, this agreement was not to stand. It was overturned on appeal, a ruling that sent ripples through the legal and corporate world alike. But the story didn't end there. Rising like a phoenix from the ashes of the overturned agreement came a new settlement. This time the figures were even higher, ranging between $5.5 to $6 billion. This substantial sum was to be funneled into a trust, a financial reservoir dedicated to compensating opioid creditors. Simultaneously, Purdue was making moves on another front. They appealed to revive their reorganization plan and settlement, a move seen by many as a desperate attempt to regain some semblance of control over the spiraling situation. But the legal landscape is ever-changing, and Purdue's maneuverings were not without controversy. The new settlement, despite its larger figure, was not universally accepted with open arms. Questions were raised, eyebrows were furrowed, and legal experts began to dissect the details. However, this settlement came under scrutiny for its legality. As the dust settled, it became clear that this chapter of the Purdue saga was far from over. The courtroom battles would continue, the legal minutiae would be passed and repassed, and the question of Purdue's responsibility in the opioid crisis would remain a hot topic of debate. But that, dear listeners, is a story for another day. The legality of the settlement led to arguments at the highest court in the United States, the Supreme Court. At the heart of the case lies the question of whether the bankruptcy court has the power to release non-bankrupt parties from litigation. In this instance, those parties are the Sacklers, a family whose fortune is deeply intertwined with Purdue Pharma. The Sacklers, having expressed regret but denying any wrongdoing, argue that they are entitled to legal protections in exchange for their contribution to the settlement. The Department of Justice's bankruptcy watchdog, however, has consistently opposed granting such legal protections to the Sacklers. This stance is shared by other states and creditors, who may also oppose the new settlement. This disagreement led to the Supreme Court hearing, where the legality of the settlement and the bankruptcy court's authority is under scrutiny. Another crucial issue being examined by the Supreme Court is whether the settlement violates federal law. The Sacklers' settlement deal did not require them to declare bankruptcy, thus protecting their wealth from OxyContin sales. This legal maneuver of settling personal injury claims in bankruptcy court instead of civil court is becoming more commonplace. Critics argue that this practice denies regular people their day in civil court and could potentially allow corporations to escape financial consequences by declaring bankruptcy. The Supreme Court's role is to assess whether this settlement and the emerging practice of settling personal injury claims in bankruptcy court align with the principles of federal law. This decision will not only impact the Sacklers and Purdue Pharma, but also set a precedent for future bankruptcy filings. The Supreme Court's decision could have far-reaching effects on future bankruptcy filings. The implications of the Supreme Court's decision could be monumental. This case is not just about Purdue Pharma, the Sacklers, or even the opioid crisis. It is a precedent-setting case that could fundamentally change the way corporations use bankruptcy as a shield against financial consequences. Firstly, if the court rules in favor of Purdue Pharma and the Sacklers, it could give a green light to other corporations to use bankruptcy courts as a refuge from civil lawsuits. This would mean that corporations could potentially avoid paying for their misdeeds by declaring bankruptcy, even when the owners of the corporation remain wealthy. This could set a dangerous precedent, enabling corporations to evade responsibility for their actions. However, if the court rules against Purdue Pharma, it could send a strong message to corporations that they cannot use bankruptcy as a shield against their obligations. It would establish that corporate owners can be held accountable for their actions and cannot hide behind bankruptcy laws to avoid responsibility. There is also the matter of the victims. Critics argue that by settling personal injury claims in bankruptcy court, regular people are denied their day in civil court. This case could potentially change that, ensuring that victims have a chance to make their case and seek justice. Additionally, the decision could impact how settlements are structured in the future. If the court rules that the Sacklers' settlement deal, which did not require them to declare bankruptcy, is illegal, it could deter similar deals in the future. This would mean that wealthy individuals cannot simply pay their way out of legal troubles. As we await the Supreme Court's decision, one thing is clear: the resolution of this case will have significant implications for corporate responsibility and victims' rights in the United States. Before we conclude, let's quickly summarize the key points we've discussed. Purdue Pharma, owned by the Sackler family, played a significant role in the opioid crisis, manufacturing and marketing the highly addictive painkiller OxyContin. Facing numerous civil lawsuits, Purdue Pharma filed for bankruptcy in 2019. In the midst of this crisis, a series of settlements were proposed. Initially, a $4.5 billion settlement was reached but was overturned on appeal. Subsequently, a new settlement between $5.5 and $6 billion was proposed. But this too is subject to approval. These settlements were designed to compensate opioid creditors through a trust, but they do not offer the Sacklers complete protection from future lawsuits. The Supreme Court is now assessing these arrangements. The question at the heart of the matter is whether the settlement violates federal law, particularly concerning the practice of settling personal injury claims in bankruptcy court instead of civil court. This could potentially impact the ability of companies to declare bankruptcy to avoid financial consequences. The implications of the court's decision are far-reaching. It's not just about Purdue Pharma or the Sacklers. The outcome could set a precedent for how corporations are held accountable in the face of widespread harm. The Purdue opioid settlement arguments in the Supreme Court is a case that will be closely watched, not just by those directly affected, but by all who care about corporate accountability and justice.